your time on council.
That's what's supposed to happen.
And on November 18th of 2008, despite the fact that Mr. Waldrop and Ms. Wilson would be released by the settlement agreement for their own tort claims, did they file anything with the clerk?
Not to my knowledge.
Did they say that they were going to recuse themselves?
No, they did not.
Did they leave the room or stay in the room?
No, they did not leave the room.
And did they participate in the debate?
Yes, they did.
And in your time on council, with regard to conflict of interest, do you believe that that was correct for them to do?
Based on what I know, if they had an involvement in it, they should have recused themselves and left the room.
Now, Mr. Tessier asked you about the incoming council members-elect and asked you about the election that was coming on. I believe your testimony was that you were absolutely sure that those council members would win election in November of 2008. Do you recall that?
I think I said something to the fact there was no doubt in my mind.
Was there any doubt in your mind when you voted on the severance that the new council would come in and do everything that Mr. Waldrop stated at the audit committee meeting in August of 2008?
Total speculation, Your Honor.
I asked his perception.
Of what someone else might do in the future.
What is it? Can you state what his perception, his understanding of the situation was? I'll take it for what it's worth. You may proceed.
Okay, ask me your question again, please.
Did you have any doubt in your mind that when the new council took office in January of 2009, that they would do anything but what Mr. Waldrop said they were going to do in August of 2008 at that audit committee meeting?
I firmly believe that they would.
Objections noted. You may proceed. You can answer the question.
I firmly believe that they would do what Mr. Waldrop had stated at that meeting at the, I believe it was held at the county museum. And that was confirmed by the letter that was delivered where Mr. Waldrop and Ms. Wilson and the three council members elected, working in unison, had asked the administrator to freeze 25 positions. So I think that confirmed my suspicions and my perceptions.
And that happened the day before the severance vote, didn't it?
I think that letter was dated November 17th.
Now, I'm going to ask you a couple questions, and Your Honor, this is subject to the proffer because the proffer's out there.
All right, subject to your prior objections, you may proceed.
And Mr. Greer, you've had the opportunity, I think, to review the minutes from the March 21st, 2006 county council meeting where the sheriff and Mr. Boucher appeared and Mr. Preston made a statement to the council. After reviewing those minutes, at any time was Mr. Preston asked if he was having a relationship with Ms. Nichols at this meeting?
No. Not that I recall.
Rereading today, and you actually went further, as I understand, in this meeting, and that you actually contacted the city chief of police in addition to taking information from the sheriff and Mr. Boucher, right?
I did.
And sitting here today, do you still have any knowledge that what was told to you on March 21st of 2006 was in any way incorrect?
I have nothing to say different.
And even if sitting here today, you found out that Mr. Preston in fact had a relationship with an employee, that issue was never raised on March 21st of 2006 during that meeting, was it?
No.
Now, with regard to the severance agreement, let me ask one more question actually before we go there. Prior to March 21st of 2006, were you as a council member and other council members receiving written, hateful letters?
Yes, ma'am.
And I'm going to show you a document which has been pre-marked as, found my notes here. Defendants Exhibit 133, and ask you if you recognize this document.
Yes, I do.
Can you tell me what that document is, sir?
Would you state that again, please?
Can you tell me what that document is?
It's, I'd call it a hate letter.
And-
It's a letter basically threatening, accusing that immoral acts are going to be performed on my person, that my financial accounts are being examined, and it's very threatening.
And what did you do with that letter?
It ended up at the sheriff's office
And why did it end up at the sheriff's office?
because, in my opinion, it was criminal in nature, and that's where it belonged, and it should be pursued and investigated.
Your Honor, I would move to admit that into evidence at this time as Defendants Exhibit 138.
Our same objections as before, hearsay and relevant.
Hearsay is to,
This is a letter from an anonymous person signed the investigator in March 2006, and no one has ever established who this person is.
And, Your Honor, we're not
what is being
admitting.
offered for?
It's being offered to show that he was receiving letters, not that someone would actually bugger him or sodomize him.
All right, objections overruled on that basis. Pass the exhibit up, I'd like to see. Thank you. Make sure.
And at the same time frame as March of 2006, did that continue through a period that lasted throughout the time you were on council, with you and other council members receiving hateful letters, hateful phone calls, things like that?
We received those letters on more than one occasion. It got to the point that I could recognize them before ever opening the envelope. And I remember that I received one, handled it very carefully, and asked for a meeting with Sheriff Crenshaw. I think Deputy Boucher was there. And I believe Mr. Dees, who is no longer with us, was there when we met with Sheriff Crenshaw and Deputy Boucher. And I carried the unopened letter to the sheriff's office and asked them to open it and see if they could secure any type of identification from the letter.
And at that time, Mr. Dees was also a council member?
Yes, ma'am.
And in your capacity as a council member, on or about February of 2008, did you receive a copy of that letter from the chairman, Mr. Thompson, to the sheriff, Sheriff David Crenshaw?
What number is that?
138. That's the one I thought I introduced yesterday with Mr. McAfee.
This is 136.
I'm sorry, 136.
Did I receive it?
Yes, sir.
I would say yes, I did.
And do you recall the substance of the complaints in the letter that Mr. Thompson was talking about during council meetings?
The one thing I remember is that he referred to the fact that he was threatened to be sodomized, that he needed to check his homeowner's insurance policy. I remember that he was referring to the very threatening nature of those letters that we received.
And Your Honor, this time I would move to put Defendants Exhibit 136 into evidence.
Same objection.
Objections noted, I assume it's being offered for the same purpose.
Yes, Your Honor.
It's admitted.
Not as the pre-marked.
Thank you. That's marked.
Now, on On the backdrop of this harassment, these harassing letters, did that weigh in any way in your decision to vote for the severance on November 18th of 2008?
Did my having received those letters weigh into the decision-making process?
The culture that was created by the harassing letters, the harassing nature, and the dispute that had gone on in this county for 5 to 10 years at that point.
Let me see if I can answer you this way.
Sure.
I felt like it was time to put an end to it. I felt like it was time for Mr. Preston to move on. And I also felt that he should be treated fairly and equitably. And that would not have been those letters would not have been an item that would have caused me to sway one way or the other, but it would have been something that would have concerned me.
And was there any reason to prolong the agony of this dispute further past November 18th, despite the fact that you had 2 more meetings coming up?
No.
In your mind, did you do the right thing on November 18th of 2008?
Yes, ma'am.
I want to ask you just a couple more little specific questions, and then I'll be done with you. Now, you said that the county attorney worked for the county over here and not directly for the council members. Now, that included the deputy county administrator. Is that correct?
Yes.
And did the deputy county administrator often directly work with the county attorney on this?
I'm assuming so.
You don't have any knowledge to the contrary?
No, I don't.
And when you all were in the personnel committee meetings and you all were talking about the severance, were you communicating with Mr. Bright about what your thoughts were as far as what was an amount you could live with in a severance?
Mr. Bright.
Well, with Mr. Bright, with your co-personnel committee members, were y'all talking about the amount?
The amount was, the amount was discussed at some point in time. Now, who I discussed it with, I'm not sure. It could have been Mr. Wilson, could have been Mr. Bright, or it could have been both. I know I made it known very early that I was totally opposed to 1.9. In fact, if you'll check the depositions or whatever, I've answered something to the effect that I wanted it to be less than $1 million.
And you don't know, sitting here today, if Mr. Bright then communicated that to Mr. Preston's legal team to try to negotiate the number down, do you?
I don't know what he communicated to them.
You don't know if Mr. Bright was telling Mr. Preston's legal team, I'm having problems getting 2 council members to give me the amount you want as a negotiating strategy, do you?
I don't know that he did or didn't.
Had you known that Mr. Thompson was seeking employment with the county, would that have affected your vote on November 18th of 2008?
No.
Had you known that Mr. Thompson was receiving appraisal courses at the cost of the county, would that have affected your vote on November 18th of 2008?
No.
Thank you, Mr. Greer. I'm sorry for the inconvenience we have caused you and the money we cost you to leave. Please answer any further questions that Mr. Tessier has or the judge directs.
Redirect. You may proceed.
Thank you, Your Honor. Mr. Greer, what I heard you say is that you just wanted to treat Mr. Preston fairly and equitably. Is that right?
That's correct.
It didn't matter to you whether or not he had any legitimate anticipatory breach claim, did it?
Yes, it did, and I thought he did.
You agree that you paid, the severance amount that you paid to Mr. Preston, you agree was in excess of any amount that he was entitled to under his employment agreement, correct?
No, I would not.
You think there's a provision in his employment agreement that provided for him to receive?
I think my answer says it fairly and equitably. And to me, fairly inequitably, we had cost, or not we, but this whole matter had cost him employment possibilities. And I felt like the settlement that we had finally settled on was a fair and equitable settlement.
You agree that the $350,000 plus that the county paid to Mr. Preston to purchase him retirement service credits is not an amount that is called for under this employment agreement, correct?
I understand that it's not what's called for, but if he were to seek damages, then that would have been part of the damages. And in an effort to avoid further litigation, I thought that was an appropriate action to take.
And you're not here to tell anyone that you believe it was appropriate to pay Mr. Preston any sum of money based on the political culture of Anderson County, are you?
I'm not sure I understand what you mean.
Well, we heard a lot of talk about how the political culture in Anderson County was toxic and people were being harassed, right?
Right.
You're not suggesting that Mr. Preston should have received any amount of money because there was harassment going on in the county, are you?
I think that's what led us to the point where we were at.
And so you think it was justifiable to pay Mr. Preston money
I
based
didn't
on...
say that.
That's what I'm asking. Do you think it would be justifiable to pay him any money based on the political culture of Anderson County?
Your Honor, I believe this has been answered twice.
This will be the last time. Okay, which one is best?
Okay, ask me again.
Are you trying to tell us that it would be appropriate in your mind to pay Mr. Preston any amount of money as part of his severance agreement because you're considering the fact that the political culture of Anderson County is toxic?
The political culture in Anderson County is toxic, and that's part of what led us to the point where we're at.
And wouldn't that same argument apply to anyone else who was working under the same political environment at the same time? In other words, we could pay Mr. Cunningham based on that as well, or Ms. Wilson, because she was going back and forth with Mr. Preston about the same type of thing.
There's a difference between the instigator and the receiver.
So you took Mr. Preston's side, in other words.
No, sir. I took the right side.
Let me ask you about Caters Lake real quick. That incident involved Mr. Preston being seen at Caters Lake with Kelly Nichols, correct?
I'm sorry?
The incident at Caters Lake that was discussed at the March 21st County Council meeting involved Mr. Preston being seen at Caters Lake with Kelly Nichols, correct?
I'm not sure that I ever had it confirmed that he was there with Kelly Nichols. I couldn't answer.
Did you know that he was seen there with a female county employee, at least that much?
I'm not sure that it was a female employee. I don't know.
You asked a lot of questions of various law enforcement officers about what happened at Caters Lake, correct?
I did.
And you never determined what he was seen there doing or with whom?
No.
You talked about the fact that you believe Mr. Walter and Ms. Wilson should have recused themselves from voting on the severance agreement. Is that what you believe?
Yes, sir, I did.
Let me just make sure I understand this. You had a working copy in advance of the November 18th meeting of the severance agreement, correct?
At some point in time.
And so you had time to figure out all the provisions of that agreement, right?
No.
You had some amount of time before the meeting, at least, to review the working copy, didn't you?
I had time to review the working copy.
And you chose not to share the working copy with Mr. Wilson or Mr. Walter, right?
Miss Wilson and Mr. Fuller.
I'm sorry, yes, Ms. Wilson and Mr. Walter. Did you share the working copy with Mr. Wilson? Did you share the working copy with Mr. Wilson? That's who you got it from, right?
Yes.
And what about Mr. Thompson?
No.
You destroyed the working copy that you had, correct?
Yes.
And at the meeting, would you agree that that's the first time that Ms. Wilson and Mr. Walter had any opportunity to look at the provisions of the severance agreement that they'd be voting on?
That's the first time they've seen it, to my knowledge.
And so they would have to decide in the short time that they had it, whether or not that provision affected them personally, right?
Yes.
And they asked for legal opinions about the severance agreement, didn't they, at the meeting?
I don't recall.
And in the end, would you agree Mr. Waldron and Ms. Wilson voted against the severance agreement, right?
Yes.
So they voted against this provision that you're talking about that would supposedly protect them from tort claims, right?
Yes.
They voted against their interest. Would you
No,
agree?
they voted against the severance agreement.
You voted in favor of the severance agreement, right?
That's correct.
So you voted in favor of a provision that would release you from tort claims, correct?
Yes.
Last thing to ask you is this. You testified, and I think I heard you right, you can't count votes in advance, right?
You try, but you can't actually do it.
There's no way to tell what's going to happen until they raise their hand at the meeting, right?
That's correct.
So it's all up in the air until the vote happens.
Yes.
Mr. Preston was making a claim of anticipatory breach, right?
Yes.
He was predicting what might happen to him in January of 2009, correct?
Ask me your question again.
Mr. Preston was predicting that something was going to happen to him in January of 2009, right?
He was predicting something was going to happen based on actions that had taken place, yes.
Just like you do, you predict what a vote's going to be like when you try to count the votes in advance, right?
Right.
And you don't know for sure, though, until it actually happens.
Right.
And based on that prediction of what might happen in January 2009, you voted in favor of paying over $1 million of Anderson County money to Mr. Preston, right?
Yep.
That's all I have. Thank you.
Yes, ma'am.
Secret question, real short.
Okay.
And I'll stand right here. Mr.
I'm gonna try to
Greer.
get through on this witness before 1 o'clock. We've got 10 minutes.
Thank you, Randy.
Go ahead.
Mr. Greer, would you agree that Mr. Waldrop and Ms. Wilson and the rest of the council knew that Mr. Preston had claims against Mr. Waldrop and Ms. Wilson since they were served with that lawsuit back in August?
Objection. Asking what other people knew.
Was it public knowledge
Thank you.
that Mr. Preston had sued Mr. Waldrop and Ms. Wilson personally back in August of 2008?
I would say yes, because just like I had to be here today, because Mr. Davis's office and Mr. Tessier's office served papers on me. So I would assume that they were aware of it.
You got a copy of those papers as a council member from Mr. Preston, didn't you? All council members did.
I probably did, yes.
And the ordinance that talks about voting under a conflict of interest, does it say voting in your benefit or against your benefit, or does it say vote, period?
It says something to the effect, you shouldn't vote if you have an interest in the matter.
And it wouldn't matter if you're voting against your interest or for your interest. If your interest is at stake, it just says vote, right?
That's correct.
Thank you. I have no further questions.
All right, so you may step down.
Your Honor, we have no problem with excusing the witness.
Any objection?
No objection.
Sir, I'm going to release you from the subpoena. You're no longer required to be present. I will caution you, I've issued an order in this case requiring that witnesses not discuss their testimony with anyone, either before, during, or after their testimony. So it would be a violation of that order if you discuss your testimony before the case is beginning. You understand?
I do.
All right, you're free to go. Thank you very much.
Mr. Greer, would you bring my exhibits with me, please, sir?
I'm not sure who.
Thank you.
Why don't you retrieve that for us, Mr. Sherman? All right.
You can ask an administrative question.
Yes.
There was a stipulation was reached in this case, Your Honor, that I believe was sent to your Spartanburg office at some point. I don't know if you happen to know whether or not that was actually filed here with the clerk of the court yet or not, we're just trying to determine.
We've mailed it to the clerk's office.
I mean, can we, is it fair for us to just operate on the assumption that it either has been or will be filed, we just treat it like?
You'll have to talk to the clerk about that. I don't know whether he's filed it or not. We have mailed that out back to the clerk's office.
And we'll make a copy of it, an exhibit, but it may be a non-date statement.
I understand, but again, I don't know what the status of it is at this point in time. Maybe check here today. All right, we're in recess for lunch. We'll resume.